ultimate podcast for all you hustlers and dreamers out there. Join us on this electrifying journey from side hustle to CEO, where we dish out insider secrets, success stories, entrepreneurial wisdom, and so much more. Everything you need to conquer the business world. I'm Kier Denine. I'm the CEO of DNA Today, and I am joined today by two people, but I'll have my co-host, Benny, introduce himself first before we get to the star of today.
I'm just simply Benny, CEO of Ishook, founder of Ishook, co-founder of Ishook, all here to disseminate information in its proper form. Go ahead.
Yes, I love it. So on to our superstar today. This week, we are discussing trademarking with the Gordon Firemark. I found Gordon when I searched. I don't know if you know this, Gordon. I searched top podcast lawyer and you came up first. And so I was like, you know what? I want to learn from the best when it comes to making decisions, protecting my brand. And wow, I have learned a lot. I'm part of his community. So I don't know if you have like cool names for us. I don't remember. But
I call them legit podcast pros.
Yes, that's it. That's it. I knew that there would be a name. Yes, I'm just blanking on it. But yeah, I am apparently a legit podcast pro. For those that somehow don't know, Mr. Firemark here is a lawyer who specializes in entertainment law, specifically in the area of digital media. So you can tell why he's a great setup for today. It makes sense that he came up first when I was doing my Google search because he's often referred to as the podcast lawyer, TM, due to his extensive experience advising and representing podcasters and YouTubers on legal matters. He's been practicing entertainment law for over 3 decades and represents clients across entertainment industries, including theater, film, television, digital media. He teaches on intellectual property, media law. He is a sought after speaker. So I was shocked when he was like, yeah, I'll come on your show. I was like, whoa, this is amazing. I mean, the list goes on and on. He's a writer of legal issues affecting creatives and their businesses. He's been featured in mainstream media, podcasts, webinars, industry events. He is highly regarded in his expertise in media and entertainment law, go-to resource for creatives and businesses looking to protect their legal interests. So Gordon, thank you so much for coming on. I am just ecstatic to dive into, we're talking about trademarking, but you know so much more than just that.
That's true. But thank you for that wonderful introduction. It's nice to know that my nefarious plan for world domination is working.
It is really
however
working.
Slowly.
Yes. You've conquered podcasting. You've really conquered entertainment law. Love to see what's next for you.
And in my spare time.
In your spare time. Yeah, I mean, you've got a lot going on. And we'll even mention kind of at the end and give shout outs for the podcast that you run and maybe specific episode recommendations and all that. But we're not at the end. So why don't we talk about what a trademark is, why it's important for entrepreneurs, because as you probably remember of our conversations before, people listening to this, they're entrepreneurs. They might be that side hustle part. They might be at the CEO level. Yeah. But regardless of where they're at, trademarking is important. What is it? Why should they be learning about this? Why should they keep listening to this conversation?
Well, thank you. That's great. Yeah. A trademark, trademark is sort of another word or a near synonym for brand. And when you think about the definition, I'll connect the dots here in a second. So the definition of a trademark is a word or a symbol or a phrase that is used by affixing it to goods and services in the marketplace to distinguish those goods from one source, from the owner of the mark, from those from other sources. So a distinctive symbol, word, those kinds of things. So when you think about it, when you would, in the Old West and here in the US, you would sear the symbol for the ranch into the side of the cow. That was so that when it came to market, they knew which ranch it came from. That's a brand, a trademark.
That must be where brand comes from, because we were branding.
Yeah, absolutely. Yeah.
So I never put that together.
That's what I'm here for.
Yes, you really are. You really are.
So what it does is it really allows you to identify your product and associate it with a particular maker or seller of those goods and services. So for example, when you think about the generic term for a cookie might be, cream-filled chocolate wafer cookies. And everybody knows that if you look for the ones that you have the red triangle on the bag and they're blue and it says the word Oreo, well, you're getting a certain level of quality. Mm-hmm. And that allows you to build a reputation with your audience that can transcend the particular package of cookies this week. And that's really what trademarks are good for.
And it really then helps in building a business and that recognition but also protecting it, right? I can't go out there, and I'm not a good baker, but if I was, and just throw on the word Oreo into a package that's blue, because that is not going to go well. Oreo is going to come after me because they're protecting their brand by trademarking.
That's right. So, but what's interesting about trademark law is that the rationale for creating this law that protects and prevents others from coming in with confusingly similar brands isn't about protecting Nabisco. It's about protecting the consumers so that they know they're not going to get duped by buying something that looks like an Oreo but actually turns out to be a cheap knockoff.
My Florio, we'll call it.
Yeah, right. So that's really the goal of this part of intellectual property law. Whereas the other fields of intellectual property, patents and copyrights, they're more about protecting the creative or scientific work of the author or the inventor of something. Here, we're talking about really protecting the public.
Okay, so there is these differences between a trademark and other forms of intellectual property like copyrights and patents. How would you differ the two for someone like me that kind of gets it, but not really?
Okay. So the trademark, as we said, is this distinctive symbol or mark that you put on goods to identify source. Copyright law protects the original expression of authors. So it doesn't protect ideas, it doesn't protect concepts or facts for that matter, but it does protect the way a particular writer, filmmaker, musician, composer, whatever, expresses those things in an original way. And that allows us to, incentivize creators to make new work and create art and so on. And it's available for a limited time, that protection. Some people think it's much too long, but that's a discussion for another day.
Yes.
But after that time, then it becomes public, and anybody who wants to can use that as a building block for the next thing, and so on and so forth. Patent is sort of similar to that, but it deals with unique and sort of non-obvious inventions, technology and designs and systems and things. Same thing, short-term protection that allows to create an incentive to inventors to do the work of inventing so they can monetize it for a while, and then it too becomes a part of the public as building blocks for the next generation of inventions.
And with the trademarking then, if that's something that business owners or entrepreneurs are hearing you talk about, and they're like, okay, it sounds like I should be trademarking. Can you walk us through like who should be doing that, I guess? Like what types of businesses before we get into how to do it?
Yeah. Well, okay. So we use the term branding a lot as selecting, identifying, and promoting a brand out into the marketplace. When you say trademarking, it always makes my scalp itch a little bit or something.
Yeah,
because
break that down.
Really,
how should I be saying it?
Yeah, it's registering the trademark.
Registering the trademark. Okay.
Right. You acquire a trademark by doing that branding, by picking a distinctive phrase and using it in a way that identifies, the source and so on, in interstate commerce, in public, in the marketplace, I should say. And when you have done that, then you become eligible to register for a federal level trademark protection through the United States Patent and Trademark Office, or whatever other country you're in. Most countries have their own trademark systems, and that registration process, it isn't required by law at all, but it does allow for a much higher level of protection for that brand. You've adopted it. It's sort of what we call prima facie, on its face, evidence of ownership of this brand and the exclusive right to use it in connection with these kinds of goods and services. And so that's the idea of registering for protection. And generally, the recommendation is once your goods are into commerce and you're serious, you're going to stick with this brand. That's either right before or right after. That's the best time to get the registration going.
Okay. I have so many questions with Benny. Definitely jump in because
no doubt. No, so I know because Ishook is a trademarked. It's trademarked, and from what experience with my attorney, there's 5 years, right, that someone can contest the trademark. Am I right? Wrong?
Well, yeah. There's a part of the process. The process of registration is a long one, and it typically takes a year or more for the registration to be processed and gone through the whole. It has to be published, and there's an opportunity for the public to comment and all that. After that year happens, then they issue the registration, but it still can be contested. If somebody feels, well, they were there in the marketplace with that mark first, or that it's just too descriptive, it's really not being used as a trademark. There's a bunch of different reasons someone might object. But once you've been using a trademark for 5 years in the marketplace, you have to file a renewal affidavit just saying I'm still using it, and proof, evidence in the form of specimens. And at that point, you have the option of also filing a declaration of incontestability. And that makes it much harder for the mark to be canceled or overturned. It's not a complete protection, but because you might abandon it or stop using it the right way and those kinds of things. But it's certainly a good idea to do. And for the added cost of a couple $100 at that point, it's always the recommendation to register and do that declaration.
Yeah, I got another question. This is like crazy question, and I know this from people who have done for business T-shirts for a living. And when you put slogans on those T-shirts, how does anyone protect their merch that way? like it's like constant. You're gonna pay for a trademark for each T-shirt. I mean, like you're gonna run down $100K just for the 100 types of T-shirts you have.
That's a really interesting question, and it raises a bunch of other sort of weird permutations. And one is that not all merely putting something on a T-shirt doesn't really act as a brand, because that's not always the indicator of source. If I have a T-shirt that says impulse control or something on it, poor impulse control. Isn't that the tattoo?
No regrets.
Well, that isn't a brand. The brand is, Firemark T-shirts or whatever.
Right.
And so what that would be called is what we call an ornamental use. So it wouldn't be entitled to trademark protection anyway. When it becomes the brand, in this case, it's the little shark, Greg Norman shark on my golf shirt, or a polo player or a alligator, that becomes a brand identifier. Then it's something you can rely on trademark protection. But with T-shirts, a lot of the time what you're really protecting is the design. You may not be able to protect that slogan. Somebody else wants to make a poor impulse control T-shirt, they're sort of able to do that. So if you come up with an original design, it's more than just the font, but either it's stylized in a certain way or incorporates other design elements, then you could have a copyright for it. And if somebody copies that whole part, the whole design, that would be an infringing action. And you don't have there's no registration. Well, there is registration for copyrights, but it's not required at all. You own the copyright the moment you create the work.
Which is interesting, because if you put content out there as an entrepreneur, you have some rights, you're saying, right away, even if you're not filing anything with the government.
Correct.
And a lot of what we're talking about is US based, like the three of us are based in the US and everything. Yeah.
Yeah. Well, yeah, that's true. There are some de facto common law rights. Copyright is one that's actually statutory. You get it when you create the original work. And trademarks, there is a common law trademark, but it tends to be regional. So if you were using it here in Southern California, you might not be able to stop somebody from adopting the same thing in North Carolina, unless you're also able to prove that you were using it there as well. So the federal registration takes care of that and gives you that blanket coverage at the national level. And yeah, most other countries, if you're doing a significant amount of business in other countries where it would hurt you to have somebody create a similar brand, it makes sense to register in those countries as well.
And you had mentioned, Benny had mentioned, like, well, it can be really expensive if you're registering multiple trademarks, if I got that phrase right.
Yeah.
I'm learning already. What are the costs associated with just like registering one trademark, so people can have a sense of, is this something I can even afford for my very budding business?
Okay. Well, first of all, I'll address, you have to ask yourself, not just can I afford it, but can I afford not to? Because the risk
that's a very good thing legally.
So it should be something people budget for. If you're building a business that is brand specific, brand centralized, you definitely want to budget for this. The government fees for registering a trademark are broken. Well, trademarks are broken down into classes of goods or services. So for example, if I wanted to create, Firemark chewing gum, let's not use my last name. We'll call it Fireball chewing gum.
Okay, I like it.
And I register in that category. That doesn't mean somebody couldn't start creating Fireball medical devices or something like that, unless I'm also making goods and services in those categories. So there's about 42 classes in the international system that we have to figure out where they belong. And for each class, for each mark, the government filing fee is $350. The legal fees will vary depending on who your lawyer is and where you're located and how complicated the process is. But I think it not unusual to expect to spend $1,500 to $2,000 for a single mark in a single class, and then it goes up. Maybe even a little more than that, because we generally like to make a search beforehand to make sure we're not going to be infringing somebody else's mark the moment we start doing things.
That makes sense. And for people to expect, okay, it's going to be, maybe $1,500 to $2,000 if you're including those legal fees, unless you're a lawyer yourself, which if you are, you're probably not listening to this because you know all this. But then also time-wise, about a year, you said. So I think that's important for people to not think, oh, I'll get it done by the end of the month.
Yeah, well, that's right. I mean, you file the application and then you wait. And you wait and you wait and you wait and you wait. The government, it's funny, on the Trademark Office website, they've got a little banner now saying, due to the increasing volume of applications, our processing times are taking longer.
Now, how long has that banner been up?
As a long time, a couple of years at least. And the Trademark Office is interesting because it's a self-funding. Its fees pay for its operations for the most part.
Makes sense.
So if you don't want them to raise the fees through the roof, we're sort of stuck with this long time frame. The good news is the registration, the effective date of the protection goes back to the date you filed, not the date it's formally registered. So again, an argument in favor of just get started sooner rather than later. Yeah.
I mean, Nike, don't sue me for saying that slogan, right? But yeah, it sounds like you should just get it going once you have established, what you're doing and you've already made that decision. And then you said after 5 years, you then have to kind of renew. Are the costs less because it's already in the system?
Well, you're not paying a lawyer to prepare a whole application and make a bunch of arguments, but it's a few $100 by the time I think the government fees are about $200 per class, and then you got to pay a lawyer a little bit of time. I guess you could do it yourself if you're smart and thoughtful about these kinds of things and so inclined. But in the scheme of things, even $2,000 to register and a few $100s to renew after 5 years, and then after the 5-year registration, the next one comes at the 10-year mark, and then it's every 10 years after that. And the trademark will last as long as you continue using the brand, which is why Coca-Cola, 100 and some years, 120 years into their business, is still able to say you can't use Coca-Cola or that typeface, or those kinds of things.
Very
shape of the
script.
bottle.
Yes.
All of these very distinctive things that identify that's a product from Coca-Cola Company.
What about I'm sorry for cutting you because you mentioned Coca-Cola. What about the color red that Coca-Cola uses? I think that was a huge issue with colors in trademark, no? Or
there have been issues in colors. As far as I know, red is not registered specifically for Coca-Cola. There are a lot of other brands that use red as their design.
No, I think they have a specific Pantone red, if I'm not mistaken.
Well, I know that the Barbie
color
doll
number
is a particular pink that is done. I know there are a few of them. One of the early cases that dealt with color as a brand identifier was a green, believe it or not, used on covers for dry cleaners' presses.
Really?
And the competitor came along and made their product the same color, and there was a big lawsuit, and ended up being authority for the idea that yes, you can protect a color when it's distinctive for a particular kind of goods. But I don't know about red because, I don't know if there's any other cola products that are predominantly a red, and that may just be smart marketing on their part anyway. Differentiate rather than try to align. But yeah, that's a.
So there is trademark on colors. That's
trademark on colors. There's trademark on sounds. There's a distinctive sound brand trademark for the Harley Davidson muffler sound.
Really?
And the sound of the lion roaring on MGM movies.
I went to a in-person conference. Exciting, right? Can we say post-COVID? I don't know. Endemic. And it was cool. Tostitos came in, and their audio engineers and stuff that came up. I don't know if you guys have seen the Tostitos commercial where they kind of come up with this 4 note jingle at the end,
Sure.
and they use the Tostito products that someone crunches, someone opens the lid,
Mhm.
and they turned it into this jingle of using that. And I was like,
Oh,
this
that's
is so ingenious.
Yeah.
I don't know if that is a registered trademark, but I would think.
Yeah.
Yeah.
I mean, there are other examples. Just 3 musical notes. GEC. Ding, ding, ding. Anybody know what TV network that's for?
NBC.
NBC?
Right.
There you go.
NBC was owned by General Electric Company, so GEC, and that sound pattern has now become a
Are those the notes that are being used? GEC.
it's
Oh
a
my
logo
gosh.
for the exactly.
Wow, that's such a fun little
You learn fun
tidbit.
stuff. when you
That's
study
good.
trademarking.
Listen.
Wow.
He's hitting the fires on every mark.
Careful, you're using my name.
Right?
Trademark.
Benny, I don't know. Are there other trademarks that you're like, I don't know, you I said trademark, registered trademarks that, am I saying it right? Now I'm thinking.
Mhm.
Yeah, okay. That you're like, that's so innovative or anything like that. Like we've kind of just talked about a few, but are there others that you're like, this is a good one to look at as a model? Or
Well, it's hard because it has to be distinctive. It has to be associated with goods and services. So there are just millions and millions of these
So
brands that
many.
have been registered. There are always a few sort of interesting ones that come up. That's the ones that the courts have to talk about. There was one involving a rock band called the Slants that was all Asian members, and the government tried to reject that application on the basis that it was a disparaging phrase for people of Asian descent. And they ended up saying, no, you're violating our First Amendment rights. We have a right to
and they're
say
naming
themselves about
themselves,
ourselves
so it's a
that
little
way.
different
Right.
than someone else naming them. Yeah.
And so there have been rules that now that part of the law has been declared unconstitutional. They can't say it's disparaging, therefore no, you don't get a registration. Similarly, profane or what they call scandalous brands used to be prevented, but a few years ago we had an apparel brand, FUKT, that when spoken aloud,
Yes.
and
It
same
sounds
thing,
like it's
and
spelled
they sued and
differently
said,
when you say it out loud.
That's genius.
Yeah.
Who did that?
and they also managed to get their trademark through after having to sue and fight it up to the Supreme Court. So those are the kinds of things that we talk about among trademark lawyers that are the
Right.
interesting ones.
Yeah.
The more mundane ones are just, are they really that similar that there's a confusion? Likelihood of confusion is the test in the law. So,
And are there any common mistakes that you see? Because you work with a lot of clients and you help them
yeah,
put
sure.
these trademarks through, and that's part of the group that I'm in with you.
Yeah.
That are there common mistakes that you see or questions that maybe I asked you or other people have asked you and you're like, okay, not really, when they're trying to register a trademark for their businesses? You work with a lot of podcasters and digital media, as we said.
Yeah. So a couple of the most common or the most dangerous mistakes that I see are selecting a brand without doing a proper search, and you end up picking something that's either already being used or that's so commonplace and really not distinctive that it becomes troublesome to claim protection. And this is a situation where do as I say, not as I do. One of my podcasts is called Entertainment Law Update. Very, very descriptive and not distinctive enough on its own. So there's this spectrum of distinctiveness. Well, the spectrum starts at one end, very generic and descriptive, and then misdescriptive kinds of things. And then we get into the distinctive and the fanciful and the coined phrases and things like that. That latter part of the spectrum is where protection can exist, but we don't want to take descriptive phrases out of the lexicon. And so Entertainment Law Update tells you exactly what you get when you listen to this podcast. Now, there's an interesting wrinkle, though, and that is that over time, you can acquire distinctiveness for an otherwise descriptive brand by long-standing use to the point where your audience, the consuming market, understands and makes the connection. So that's how you get Best Buy or Pay Less Shoes or something like that. Very descriptive term, but because it's so well known, it becomes distinctive through that secondary meaning. On the other side, you can get a brand that's so widely used that it becomes generic.
Kleenex.
Well, Kleenex is still a protected brand because they've taken great pains to always say Kleenex brand facial tissue to
Sure.
identify the generic and make it clear. But in the 80s, the Xerox company almost lost the right to claim Xerox for copy machines as distinctive. Everybody would say, "Can you Xerox this for me?" Even though you were going down the hall to a machine made by Minolta or something like that.
Minolta. They used to own.
A few examples that we call it genericide. It's dead. It's generic now. Cellophane, Escalator, a few others out there that, aspirin is
Jacuzzi and
another
hot
one.
tub.
I don't
Like,
know if Jacuzzi
is
still
Jacuzzi-
manages to hold on to their protection for that.
Yeah, interesting. Okay.
I know that the folks who make the inline roller skates, rollerblades, had an issue a few years ago. If anybody's really geeky about this kind of thing, go on YouTube and search Velcro lawyers video. And
Interesting.
the lawyers for Velcro made a bunch of lawyers singing a song, making a music video about why it's not just Velcro. It's not just hook and loop. It's Velcro, that kind of thing. So these corrective advertising campaigns can become necessary if you're getting close to generic. Band-Aid is another example of something that they've had to be very careful about. So.
And you've written about trademark scams as well.
Yeah.
I've seen at least one article from you written about that. Off the top of your head, what are some of the more common scams that business owners should look out for, and how entrepreneurs can protect themselves?
Well, usually the scam is that someone has either filed or their lawyer has filed an application for a registration. And because when you're filing with a government agency, that's a public record. And so the name and the address and the phone number and the email address of the applicant are often part of that public. They are required to be public record.
That's scary.
One of the scams is you'll get a phone call saying hi, and it appears to be coming from an Alexandria, Virginia Patent and Trademark Office phone number. It's been spoofed, and they're trying to get you. They tell you, "Oh, we've got your application. Everything looks good, but we're going to need more money for this or that, or we have to do a publication or something like that." So what I would say is, don't trust those kinds of things when you hear someone, especially if they're asking you for money or more information that you've already, completed an application, things like that. Check in with a lawyer, check in with a service, or hang up and call them, but call the trademark office back.
Right. Say, okay, I'll just call you back. Like, who am I
Right.
speaking to?
Yeah. Can I, what's the office number or something like that, and see if you can do that. So that's one scam. The international application is another thing, because registering in one country doesn't protect you worldwide, but it does get you, if you register in the US, that gets you into a system called the Madrid Protocol. It's part of a treaty that allows for international registration, and your US registration becomes the basis for your registration in other countries. And it's very complicated stuff, but you have sort of priority with a proof of the use in the US first. So, and that's true, in the tit for tat fashion with other countries. So, but you'll sometimes hear a phone call or a letter saying, "You need to do this right now." And, again, more money or whatever. So anytime they're asking you for money beyond what you've already paid, be skeptical.
I mean, I get always the mail that,
Sure.
pay 300, 400. I just paid. Why are you asking me for more money? Like, it's obviously a scam.
Right. And you'd be amazed how often people just cut the check, and then, they'll get a little certificate. If they're lucky, they get some kind of a little certificate back saying, "Great, you paid the Trademark Assistance Center this." And there's no such thing as the trademark. At least it's not a government agency.
Right.
So.
It's an assistance for someone.
Right. They assist us with lining our pockets with your money.
Yeah.
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 That's crazy. Yeah. People's got to be careful with that.
Mm-hmm.
Well, I have a question in their entertainment side of things.
Yeah.
Right. So a lot of podcasters, how do they sign contracts and deals, either with a brand or with what should they be looking for, the tall tales of whether they're being taken advantage of or not?
Wow. That is a very big question with, sort of lots of answers. I think, look, obviously being careful and thoughtful, the first deal that most I don't know most, but if you're podcasting as a part of a team, that's the first deal that needs to be made. What's the relationship? I call it a podcast prenup. We really need to set up the structure of the relationship first. And sometimes it's about setting up a company, an LLC or a corporation, to house the venture. And then as you start going out into the world and dealing with contractors and things, there's lots of contracts that we need to be negotiating and working out. But I think you're talking more about a brand deal or a network or something like that. What I would say is, really understand the business that you're now getting into. If you don't understand it, seek out some advice from someone who does understand it and can bring a critical eye. It's exciting to, hey, everybody wants to go to the dance, right? So it's nice to be asked, but what do you have to give in exchange? That's really, there's no free lunch. There's always something in exchange. So think hard about whether that's really worth it and what you're going to get. The length of time that a deal is in effect is an important consideration. It's not just about dollars, but dollars over time and what's that worth. But ultimately, I think the best thing to say is get some advice. It'll be less costly in the long run to bring on a lawyer to help you negotiate a deal if you don't fully understand what's on the page or what the deal is. What often happens, I think, is people make quickie deals over email, and it covers 3 of the points that we might need to cover, and the 27 others that we didn't cover are the ones that later become a problem. So
but when is it too much? Like I feel sometimes when I make contract deals, I think sometimes it becomes too much of writing, too much of detail. There's no opening. So that's usually my contracts. I say a clause, we have a right to amend the contract as things progress for adaptation and for evolving, evolution of a podcast, like what we're doing with Kier as well, with all the other, what I do myself with Ishook as well. I mean, I'm CEO, but I'm still a separate entity than my own company.
Yeah.
So, we have to have those types of things in place. But I think overdoing it, especially in the start, is like you're calculating things that have not been done yet or have not come into fruition yet. So, how does a person really manage that? I mean, for me, that's how I manage it, but I don't know how.
Well, I get the call a lot or the email nowadays from clients saying, can I just get a 1-page deal that does this, 1-page agreement that does that? And my answer to that usually is no, 1 page isn't going to do it, because by the time we've just finished saying who are the parties and what are their addresses and what's the contract about at the top level, broad strokes, we're already down to the bottom of the page. Then we have to get into who's responsible for what, and so 1 page may be a little bit of a too short kind of a thing,
right?
But a lot of people will sort of push back at 3 or 4 pages and feeling like that's too much. And, I guess sometimes the deal, if it's a small deal, then we don't want to spend the time and energy. That's a judgment call you have to make.
I mean, we're not going to have a 100-page deal for a podcast.
No, well,
it's not a mortgage.
Depends on the podcast and what's involved.
If you're Joe Rogan and you've got 100 million downloads a month, you're going to make that deal with Spotify in such a way that, probably not 100 pages, but it's probably 30 pages long.
Yeah, no doubt.
And the truth of it is, a lot of that is just defining the math. We're going to get a share of the net profits. Well, let's define, what does that mean? And nobody in Hollywood ever does math the way the rest of the world does. So, you have the gross income and all the things that are deducted and all the calculations and the interest rates. And, sometimes it just takes that much time to make to answer the equation. But also, Benny, you said there are those things that haven't come to pass yet. Well, that's what the contract is there for, is to try to anticipate all of the what ifs that could happen. What could go wrong? What couldn't go wrong? What happens if we don't go forward with this deal when one of us stops doing our part or putting in the money or, whatever it is. And so we often have to take a half a page to address that part of it or something. So I think brevity. Well, I'll tell you, when a client calls me and says, hey, I want you to look at a contract and it's a page or two long, the question that goes through my mind is, what's not here? What's missing? What is unspoken? And sometimes a short deal memo does the job, but more often we need to include that boilerplate, because boilerplate's there because it's been established over time. We've figured out that if we don't say this, it can cause this problem over there.
No doubt. Yeah.
Like, what state should we have the court case in? If you're in New York and I'm in California, Should we just go to Nebraska to have the lawsuit? So, and we'll use North Dakota law also.
Right.
But sit in Alaska.
Right. So, the law does a decent job of defaults for some of those kinds of things, but sometimes those defaults aren't what you want. And again, the contract is about setting expectations and relationships. And my experience is that when you show the world that you are serious about the business that you're in, it takes you more seriously. And that is the beginning of the path to what I call legit podcast pro. Legitimacy is about being a professional, not just on the quality of the sound, the quality of the video, the quality of the output, but also what's going on behind the scenes and in the back office. Because the accounting is important, tracking your numbers, keeping track of statistics and analytics, and getting the business. And I think people respect it most of the time. If somebody says too much, I don't want to bother, then either there wasn't enough at stake or they're not a good choice.
They're not that
to be
invested.
In business with.
Yeah. And with, speaking of like, if you do have to go to court and all these things and, when issues arise, once a trademark is registered, how can business owners enforce, hey, you're using something that infringes on my trademark, if I'm phrasing that right? Is it as easy as like, and again, correct me, like a cease and desist email? Can you just do that? Like, what happens from your perspective when a client comes to you? If I were to come to you and say, hey, this podcast is a competitor. Yeah.
Totally. Great question. First off, I want to just say that when you own a trademark, you do have an obligation to what we call police it. That is to be aware of them and make sure you're finding out when someone else is using it, because if you sit on your rights, you may find that they're gone when you go looking to enforce them. So enforcing, or I should say policing the trademark is important. And that means that when you discover that search result, a Google search, or we have monitoring services and things that we use also. When you have those results that says, hey, someone's created something similar, you need to do something. Oftentimes that email or letter it's always the first step. I wouldn't recommend, just picking up the phone and having a chit chat. I would make it sort of more formal, but I've seen plenty of clients when they own that registered trademark, other people recognize that's a pretty significant hurdle to overcome, and they don't want the trouble. So I've found that the more flies with honey approach really applies, and try not to be too adversarial, confrontational in that first contact. In fact, I have one client who has a podcast with a name that's commonly enough adopted that I would say we're doing a couple of times a month. We're sending out a notice to someone. And I always say, you should send out the first notice. You don't need to have me.
That was going to
be
one of my questions. Yeah.
And she writes a note that says, hey, listen, I'm sure you didn't realize it, but you're using a title that is too similar or identical to mine. And I own a registered trademark. So I don't want to have to get the lawyers involved. If we can come to an agreement that you'll shift over to a new brand within a certain amount of time, then we'll be done. And I'd say 9 times out of 10, they just say, oh, gosh, I had no idea. Sure, I'll change the name. And it's a lot easier if you catch them early on. If they're 60 episodes into a podcast, it's a whole big deal to change.
Yeah.
If they're in episode 3, it's easy, right? So that's the first step. The next would be the more formal written cease and desist letter from a lawyer. And there's no magic to cease and desist letters. It's just a letter saying, we know what you're doing and we want you to stop. And if you don't, we're going to do something else.
Okay.
And then the next step,
simple.
Again, when it comes from a lawyer, it has a different kind of gravity than if you write it yourself. But there's nothing saying you can't write your own cease and desist letter. Just, are they going to take you seriously? But if you can cite that registration number and they can go look it up and see, oh yeah, it's registered.
It will probably scare people enough to be like, oh my gosh, I do not want to get sued.
Yeah, I guess it is a scare tactic, not a tactic.
A little bit.
It's a scary thing to get, but
it's more of a deterrent.
I was going to say
that's a good
informing,
word, Benny.
Okay.
Educating. Hey, you should have done a search before you adopted this brand, right? And podcasters are notorious for picking a title and then putting it up on iTunes and then finding out that there's 14 others with the same very similar title.
Even
or
us
something.
finding the name of this show took a while of just
Sure.
what's out there, what we don't want to be copying anyone else. We also want to be original in the sense that we say, go search Midnight Market, like we're the ones coming up. Yeah.
Right.
Yeah.
And plus it's a Midnight Market at Ishook, and Ishook is already trademarked. So it becomes more solid. I mean, doesn't mean that we're not going to be doing the trademark for Midnight Market.
I was going to say, if somebody else already had Midnight Market or Midnight Marketing or the Midnight Market, the Ishook probably wouldn't be enough to distinguish them, but it certainly is a good idea. It definitely helps to create that connection between the brand and the
Right.
owner.
Right, for sure. But I mean, Midnight Market is like market and midnight are two very open words. It's very hard to, really trigger.
Well, I'll tell you, just because a word is widely used doesn't mean it can't become a trademark. Even just a single word in the language. And famously, there was a podcast for a while there by a very prolific podcaster called Entrepreneur on Fire.
Yes. John Dumas. John Lee Dumas. Yeah.
And he apparently, the story is, this is all hearsay, but the folks with the magazine, Entrepreneur Publication, Entrepreneur Media, came along and alerted him that, hey, you're using this in a field that we occupy, so you better stop. So he did change the name. At least that's my understanding. So I may have gotten
and that's a very
details.
established show. I mean,
yeah. And again, he was he was also doing a daily episode. So after a year or two, he's already a couple hundred episodes in.
Yeah.
So again, a bigger deal to change over a brand after that long. So again,
right. But in his case, would he have to have changed every intro to his show if he said Entrepreneur Fire? What was it called? Fire?
Entrepreneur on Fire.
No. Well, I don't know that they would have made him go in and edit the audio, but certainly the artwork and the metadata and those kinds of things. And, I mean, if push came to shove and if I was representing one of these brands and the other guy was not willing to be reasonable and make some accommodation and adjust, I might hold their feet to the fire and say, well, then you're going to take those episodes down because they infringe our trademarks.
Wow.
And whether a court would actually order that, I don't know. But,
you think so? I don't know.
It depends. Again, these injunctions depend on the sort of the cost benefit for both sides.
Is there hardship claims that you can claim in such scenarios?
Well, the court is supposed to weigh the relative hardships for the trademark owner if it's not granting an order, and for the alleged infringer if they do grant that order. And there's a bunch of market factors. It's a getting a court to issue a restraining order or an injunction is no small feat, but it does happen.
Wow. Yeah. I mean, honestly, this is very important. I mean, people who are doing branding, and most stuff are branding. I don't think it's at all service right here. I mean, every podcast is a brand. We have a lot of people who podcast and they're not successful. No one wants to hear them. But when they brand it, everybody wants to hear you.
Well, that's right. And I guess the takeaway from all this is to say, listen, if you are starting a business of any kind, not just a podcast or a YouTube channel or whatever, and you're looking at adopting a brand, do a search. And I'm not talking about just a Google search. I mean, you start with Google. If you know there's others out there from that, you don't have to go any further. Find out if the toplevel.com domain is available. That's a good indicator that if it's available, you're clear.
It's great advice.
Although, again, we could have that chewing gum and medical devices difference. So, but inform yourself. Go find out what's out there and make a judgment call. But there are trademark search firms that run a fairly comprehensive analysis of all the possible everywhere this phrase appears in anything, and they go to the books and the libraries and the newspapers and the everything.
What people used to do on a regular basis, right?
And you get sometimes a very, very. I mean, I think I did one a few weeks ago for a brand that I thought was pretty distinctive. It was like a 1,400 record report that I got back.
Whoa.
And we're not going to print that PDF.
No.
big long report that had listings of probably the first 5 were sort of the closest similarities and things we would really be concerned about. But it even gets into, hey, there was a blog post in 1996 with this title. And, sometimes it's sort of, we should pull that thread a little bit and see where it takes us before we decide to adopt that brand. The other thing is you might find out that someone has used that phrase in a way that is accepted within a particular industry that isn't a very good reflection on what you're doing. So there's something to be said for doing the search just to find out that your brand is not just available, but safe and smart. So I would say that investment of $500 or $1,000 in searching and using a lawyer to help you analyze that is well spent also, especially at the launch phase of business.
What about usernames on YouTube channels in your brand name? I know that is a huge thing. I mean, I don't know, like that bothers me a lot. I don't know how to even attack those kind of stuff.
Yeah, it's interesting. I'm dealing with this myself. I am Firemark on all the social media channels except one, and on YouTube and so on. But there's another one out there that's Firemark, and he's not a relative because I know all the Firemarks in the world.
Yes.
And he's an artist, or I think it's a she actually, an artist and doing something completely different from what I do. So I'm not too worried about the confusion, but there could be scenarios where there is. And certainly if they were coming at me and saying, and doing criticism of me using my own name to do it as part of the handle for the YouTube channel, I might have the basis for some kind of an argument there, even though I don't have a registered name, trademark for my name. But my podcast titles, those kinds of things, certainly. Yeah.
Could you use because I had that issue too, that because for my main show, DNA Today, we started that in 2012. So as social media platforms kind of emerged over the last 12 years, it's like we would join them. We had all different names. And so a couple of years ago, I was like, all right, this is not working. So I was trying to have @DNA Today for everything because that's simple. That's the name of the show, right? But there was like some person that owned like the Facebook one and the Twitter one, X now. And I even offered money. I was like, hey, I'll pay you. Like, it was just like a personal account. So I'm like, why wouldn't they want the money and stuff? And they're like, no, I love it. And I'm like, okay, well, but if I had a registered trademark at that time, would I have anything to say, hey, you can't have this username?
If they were talking about and covering subjects similar to what and with that name, that's pretty likely, I would think. If you had registered the trademark before they registered their domain or registered that name, the issue is if they got there before you, then you're sort of out of luck.
And if they're just posting family photos, it's kind of like, all right, you're clearly not talking about what my show focuses on. Yeah.
So again, that's part of what that search can reveal early on, a pre-use search. Branding is look, let's face it, this is the foundation level of building a business, right? Picking out what are we going to call this thing, this product or this service that we're selling. And you don't want to be confused with others, and you don't want to be disparaged by a negative comparison. And you want to make sure it's available for all these things. And they do a domain name thing as part of the search. So
all that is so important. We ended up with DNA Today podcast, so it's still good, but DNA Today would have been better, right? So,
we had the same thing with Ishook because Ishook is also some sort of a Korean name. It's also an Arabic name.
Oh, interesting.
And people's there's only one other Ishook that actually reached out to us. She was like an artist / makeup designer or some sort of clothes designer. I'm like, first of all, we already trademarked. If you want, go complain. But if anything, I have more rights than you do because we're a social media brand that does all digital content. So,
and you're not really competing from what you're saying.
No, I didn't go against her because what they're doing is very micro, and we're like in a macro situation. So I'm not going to just sue her for no reason. Let her do her shtick because she did have it before us, and she's not really doing what we're doing. So why would I fight her?
So that's a factor in that question of, is there a real likelihood of confusion, or is it just the fact that there's a couple out there? But certainly in a space like podcasting, if you were adopting the same title or very similar as another one that's already out there, And when I say podcasting, I'm really talking about entertainment services more
Right.
broadly, or education services too. If there's, I don't know, if there's a video series or something like that out there with the same title, that could be a problem. Or I always tell people, go look on Amazon also. If there's already a book or two out with that title or a very close title, then that's a good indicator of choose something else to avoid that confusion.
You got to look at all types of media. Yeah, it's not just one area, as you're saying. You really need to do that search and research.
I've seen movies and books have multiple books with the same
Well, that's
name.
the thing. A single book, the title of a single work, isn't a trademark. It
Right.
isn't something that can be protected, but and it can be when it becomes part of a series like Star Wars or
Okay.
Harry Potter or For Dummies, those
Right.
kinds of things. But if you see that there's already a couple of books out there on the subject of, Bitcoin for podcasters or something, that's and they're all using similar phrases, that's a good indicator that the term is more descriptive or generic than
Okay,
trademark.
gotcha. That's a very
So
good
that's why.
sign.
And again, it's a free way to search. Just go look on Amazon and see what's there. Amazon, Google, those kinds of things.
And as we kind of wrap up today, as we mentioned at the top of the show, you also host a few other podcasts. You are a fellow podcaster. Entertainment Law Update is the one I'm most familiar with, but you also have Legit Podcast Pro, More, Better, Faster. With these shows, I know I'm kind of putting you on the spot, so all good if you don't remember,
Sure.
but are there any episodes that you would recommend people to check out to kind of learn more about what we've talked about today in terms of registering a trademark and what is surrounding that?
Oh boy, I'd be hard pressed to identify a particular episode of a
Yeah,
particular
I can't
show.
do that for my own shows. So
I do talk about this trademark stuff fairly frequently on Legit
Yeah.
Podcast Pro, which is a YouTube live stream as well as a audio podcast. So if you're interested in the stuff we've been talking about today, I think subscribe to Legit Podcast Pro and check it out. But yeah, Entertainment Law Update is much more of a news-oriented show where we're just covering what's happened that last month. And so we do talk about trademark law almost every month in one regard or another, but it probably wouldn't be very interesting for the non-trademark lawyers in the group.
And you also have a great newsletter for people that are in your Legit Podcast Pro community and
Oh, yeah.
everything. And you have
Thanks.
a lot of good resources. I think pretty much everything I've learned in this area has been from you. So just thank you for being my guide in all of that. Really appreciate it. And just all of your insight today. I love when we have people come on that I know, because I'm like, great, this can be a conversation and I just know you're going to bring it. And you so did. So Mr. Firemark, I very much appreciate it. You brought on the fire. We really enjoyed just talking to you and being able to spitball questions and that
Thanks.
you had answers, even the curveball ones.
Well, that's great. Hey, listen, you mentioned the group Legit Podcast Pro. There is if you go to legitpodcastpro.com, you can join up and become a part of that and
Be a member like me.
and hear from me more often.
Yeah, because you do
God
a
forbid.
monthly, yes. You do a monthly thing where we just get on and like chat with you and like, hey, this came up. And like, it's very great, not only to connect with you, but the other members in the group, because there are a lot of obviously fellow podcasters. So,
Yep.
and a lot of
that's
entrepreneurs have a podcast.
Yeah,
So at
that's
least
the
for
Easy
that
Legal for
subsection.
Podcasters program that I run.
Yes.
That is, it's actually a course that teaches folks how to do these things that we've talked about today for themselves with some sort of customized guidance from me and forms and templates and things. So if you're interested in that, you'll hear more about that if you've joined Legit Podcast Pro too.
Definitely.
Yeah,
we're
it's a
gonna
great
put it. We're gonna
setup.
put it down in the
Awesome.
descriptions in our YouTube channel. And listen, Mr. Firemark, it's been a pleasure to learn it from Mr. Firemark about trademark. So you get the,
Yes.
get the bud.
But he's always trying to make like a little line,
I'm trying to figure
little
myself out. That's
flip.
all it is.
Yes.
Well, I appreciate the opportunity to be here. Thank you both for
No
having me on
doubt.
the show.
And I'm gonna subscribe. I'm subscribing.
Oh, great.
It's gonna be
Yes.
this weekend.
Awesome.
Kira's gonna
Yeah.
send me all the emails where to go, and I'll
He already
pop
knew
it
I was
up on
going
our
to do it.
YouTube.
Yep.
It's been great. It's been great.
Yes. Thank you
Great.
so
Thanks for having
much. And thank you everybody for tuning in. I hope you guys learned at least a little bit, probably a lot.